Good morning, everyone. We're just waiting for the parties to join and then we can get started.
Good morning.
Morning.
Good morning. And for those just joining, we're waiting for the parties to join and then we'll get started. So we're hoping to get started right at 9:30.
Morning.
Good morning.
Good morning. I think this is everyone. So we're good to get started if everyone's ready. Good morning, everyone. Today is Monday, July 21st, 2025. The time is 9:30 a.m. And this is a status conference, the matter of William Castro before the Massachusetts Peace Officer Standards and Training Commission. This proceeding is open to the public and we're convening remotely over Zoom, and the status conference is being recorded. The Honorable Kenneth J. Fishman is the presiding officer over today's status conference. My name is Lizzie Smith and I'm the hearings administrator for the Post Commission, and this matter is now before Judge Fishman.
All right. Good morning, everyone. If counsel would state their appearances for the record, please.
Good morning, Your Honor. Timothy Hartnett on behalf of the Commission.
Good morning, Your Honor. Walter James on behalf of Mr. Castro.
All right. And I see that Mr. Castro is attending as well.
Good morning, Your Honor.
Good morning. All right. So before I get started on the issue of the pending motion for evidentiary hearing to vacate the suspension order, I just want to get a better sense of where the parties stand on discovery. Mr. Hartnett, and I also saw a minute ago a motion filed by, perhaps last night, on behalf of Mr. Castro related to some discovery issues. I read that very quickly, but I got a sense of that part of it. But overall, what's the status of discovery, Mr. Hartnett?
Sure. We produced everything that came from the Division of Standards. This case was unusual in the sense that the requests were so broad that included stuff beyond the Division of Standards, which is, as far as I know, I think the only time we've ever had to get anything outside the Division of Standards is somebody may have asked for some particular document from certifications. But otherwise, it's been limited to what we have because we're the ones who are, we're the part of the commission that's really bringing it and the ones who investigated it. Because of that required me to go through other, I can't review everything that goes through everything in the commission because everything in the commission includes emails from even you. And I obviously shouldn't be reading those. And so that has to go through legal. And I've started that process of trying to have them pull stuff from other divisions. But I only got, last week, very late last week, I got some initial results, but it needs to be whittled down because if you came back with way beyond what is any guy can even review.
When did you get this broader request?
So this was his request. It was in May, and I responded in June.
Okay.
May, I think it was, and then I sent my response in June and explained in the scope that the initial scope was through, what we usually do, and then then we decided we needed to make it broader because given how broad it is now. At the same time, I don't see how any of how documents from any of the divisions are potentially relevant to the actual issues in this case. So, but it's hard for me to sit there and fully 100% object until I've at least seen them. So I wanted to make a good faith effort to at least try to find those so I could do that. But generally speaking, there's no way that emails, about the scheduling of this case or, other things that I don't have are relevant to the charges that I brought. I never saw them. They certainly weren't part of the thought process for the charges.
Do these requests include material that is beyond the commission? It's really from outside sources, even beyond the division, but beyond the commission as well?
No.
Okay.
No, well, I mean, one of the requests is for a subpoena for somebody, but that's not even a proper request, so I don't know what that was about. But no, I mean, we just said no to that. We don't have such a subpoena.
But the material you're talking about right now is from other divisions or perhaps from the commission itself,
Correct.
right?
From the commission in the broader sense, beyond the standards.
Okay. Well, that hasn't been brought to my attention yet for determination of what's appropriate, but I understand that's because you're trying to decide what's out there. Is that right?
Correct.
Yeah. Mr. Jacobs, what do you say about that?
I'm not opposed, Your Honor, to Mr. Hartnett trying to do a diligent search of issues. Certainly, we are not asking or seeking simple thing, or certainly don't want communications with Your Honor. That would be inappropriate, and we don't mean to seek that. That would be privileged communication. As far as scheduling things, those are not really the issues. There are some things that concerned me in the response of the division, and that was a general objection. And I believe in the motion that I filed with Your Honor yesterday, I indicated my concern that there were references to privilege, work product, and confidentiality. I believe I understand work product, although that's debatable. I know I understand privilege. Confidentiality, I'm a little unclear what the division feels is confidential. Certainly, I think many records of the division would be confidential with respect to just being put out in the public sphere, but they may very well not be confidential in that they're not discoverable by Mr. Castro, who's trying to defend himself and his career and his certification. So I asked for a privilege log for things that the division is not producing. Now, I am not asking, and I'm not trying to be difficult, I'm not asking for a privilege log for simple emails between secretaries to schedule a hearing or something of that sort. That has no concern of this case at all. However, when we know there are emails and communications between outside people in the city of Lawrence and the Post Commission, and we believe that people at Post are telling that person he does not need to turn over documents to Post, that the mayor of the city of Lawrence ordered that person to turn over, those become very problematic when one of the charges against Mr. Castro is that Lawrence did not do anything to evaluate the car pursuit, when indeed the mayor had done that and ordered all of that report to be sent to Post. And the officer who was the liaison to Post refused to turn it over, apparently, and was told that was okay, to our understanding, by someone from Post. And that forms then the basis of an allegation against Mr. Castro. Remember, Your Honor, one of the serious problems here is there was a summary suspension. That summary suspension did not give any interview of Mr. Castro before it took place. He was not questioned or asked one question. And the mayor of the city was never inquired, did you, sir, do an investigation? We don't have a record of it. No one asked him. They just summarily suspended. And more troubling, we asked for all the minutes of the meeting at which the Post Commission summarily suspended Mr. Castro, and we're told there are no minutes. There are no meetings. I may be wrong, but my understanding under the public meeting law and under the commission's CMR, that if there's a request or a suggestion or a recommendation by the division to conduct a summary suspension, that there's supposed to be a meeting called. I believe that goes to a single commissioner. And then if the single commissioner concurs that that is an appropriate step to take, then a meeting is called or it's put on the agenda. The agenda would be a document relevant to this case, and a decision is made. The only exemption to that being all public is if for some reason someone is saying something was done in executive session. But I don't believe that's been averred in this case. So we're told there are no audio or video of a meeting by the commission to summarily suspend Mr. Castro. And we're told there are no minutes of any meeting at which he was suspended. If so, we have serious concerns whether the action to summarily suspend him was even lawful, especially given that the commission has already faced litigation for violating the public meeting law.
All right,
And
let's not get onto too many wavelengths here so I can deal with
my
the
apologies, Your Honor.
debate. No, don't. I just want to have you stop for a moment so I can address the two issues I see you just raised. Excuse me. With regard to communications with people by email or otherwise, Mr. Hartnett, wouldn't that, and you're concerned that it could involve other divisions and other things, but that kind of communication, wouldn't that go to your division?
Sure. So communications that we had with other parties during the preliminary inquiry. So it's not accurate to say that we just made a vague confidential claim. It's in the response, and it's the confidentiality is based on the preliminary inquiry is confidential by statute. So the information we gather and the communications and the steps we take as part of a preliminary inquiry are confidential, including emailing parties to request documents. Now, if we got documents and the documents themselves, we will produce the documents, but the communications to get those are our investigative steps. Those are confidential. That's confidential information that we're not going to turn over because it's confidential under the statute, and it has to be because it's not just this case; it's all cases. We need to maintain our confidentiality and our investigative steps for that process.
Let me ask you the hypothetical based on what Mr. Jacobs said. I understand that if you received materials that you included in your preliminary investigation, those would have been turned over. But if there were communications of the sort that Mr. Jacobs is talking about, where third parties are told, no, you don't need, even though the mayor wants to send this particular material to you, you don't need to do that. Is that something that you would put into the category of confidential communications?
I don't even know what he's talking about, Your Honor. To be honest,
that's why I put it as a hypothetical.
I mean, I don't. Yeah, no, I mean, I don't. I mean, no, I don't know that would be necessarily confidential. I don't know. I'd have to read it, but it doesn't exist, so I don't know that there's nothing for me. Like no one. I'm not sure what he's referring to, and if he has an email and he wants to point to something, and I'm happy to address it on that way. But I mean, candidly, I mean, honestly, I'm not sure where a lot of those allegations that were just made come from. If you actually looked at some of the documents that were produced, you would see that's not accurate. So
that you received requested information. And that's what you've produced. Hold on, that's what you've produced in discovery.
Yeah, we produced a fair amount in discovery. We produced these documents we have, and emails between. I'm not sure what he's referring to when he says that somebody telling somebody not to produce something. I don't know what that is.
All right, so stop right there for a moment. And the second issue that he claimed is that you responded that there were, with regard to the suspension, that there were no records of a meeting of the commission or minutes. Is that accurate?
Well, I said there were no non-confidential records. The executive session is not a public record. It is confidential for purposes of the commission. I mean,
so presuming there was a meeting and minutes were kept of that meeting that led to the suspension, it's your view that that's included in the confidentiality provision of the statute?
Yeah, it's confidential in terms of potentially relating to preliminary inquiry. It's also executive session, and it would also be attorney-client privilege because we're talking about communications between me or some other member. Well, it was me and a member that an attorney making a legal analysis to the commission. That's by definition attorney-client privilege. So, and that's an exception to the executive session that doesn't, it's also an executive session anyways, but it also says, you don't have to turn it over if it's attorney-client privilege.
Okay, so the issue of attorney-client, I'm sorry, the issue of attorney-client privilege kind of even goes beyond the issue of the minutes right now. I have a sense it's going to get raised in other contexts as well. And I will need to discuss that with you a little bit more in length. For instance, whether the division wears two hats. At some point, they're, serving as a attorney to the commission and providing advice and confidential communications with the commission. And then they seem to put on if you will, a prosecutorial hat and become and to pursue the case against Mr. Castro. And the question is excuse me, will be whether you view that after the preliminary inquiry and an order to show cause is issued, whether additional communications with the commission itself remain privileged as confidential communications.
No, I don't. I mean, generally speaking, I don't think I would. I don't know on a hypothetical, but I mean, I can't think of any that would be,
Well,
right?
it's going to become more than a hypothetical, because there'll be an issue here when we get to it in a minute about this future suspension, vacating, hearing on the motion to vacate the suspension, because I'm going to have to make a determination about what they get to see in connection with preparing for and addressing those issues. And so it'll kind of depend on what hat you being the division wore during the suspension hearing, and any materials that were presented to the commission that resulted in the suspension, whether that's something that the respondent gets to see.
Yeah. Sorry, I'm a little confused as to what the question is here.
I'm trying to confuse you. I'm glad it worked. No, I'm teasing, but let me just put a hold on that, because it'll be better in context when we get past this discovery issue and I address that more directly. But it was anticipated that the division might be asserting an attorney-client relationship with the commission, and I hadn't thought about it yet in terms of whether they would get the respondent would get to see the minutes of this hearing that led to a suspension, or and that you say that is done in executive session.
Correct, Your Honor. I mean, in another context, you requested that I turn over the records that were submitted to them, and I did, and that would include the minutes. So you have them.
No, I know I have them.
Yeah.
And that's why I'm able to ask these questions, not hypothetically.
Okay.
But
Yeah.
I think the record they get to know at least what I have, not necessarily see it, because
Sure.
you're saying but in terms of generally, I mean, this discussion becomes more pointed if we're not talking hypothetically, and we can say, well, sure, there are minutes of that meeting. It's just that they're not discoverable based on, according to you, based on the fact that they were in executive session and the fact that the hearing itself contained attorney-client material, right?
Correct.
Okay. And the next question, just to think about for when we get there, is whether anything that you presented in support of a request for suspension would be discoverable, or whether you're asserting that too is subject to both attorney-client privilege and confidentiality under the statute. Okay, just don't answer it yet, but just think about that. That's really where I'll be going shortly. Okay, you following me? Now, Mr. Jacobs, just so we can put a fine point on this, do you have evidence that leads you to make this demand for communications with the commission, for where the commission or the division tells them you don't have to turn over that material, even though the mayor is saying turn it over?
I do, Your Honor. I have emails from an individual at Post to Lieutenant Rossi in the Lawrence Police Department, number one. I do not know what else is there that I have not seen, although we have obtained certain things through FOIA requests. But I think Your Honor brings a point that the commission is trying to function with two hats and claim the privilege of counsel in both capacities. What the division seems to be saying, number one, is they can do whatever they want in executive session, and because in executive session, it's hidden from the public. I believe that's a violation of the open meeting law. They can hold executive session only for statutorily limited purposes. If they're going to take a vote, and this was brought up in the prior litigation, if they're going to take a vote on an officer under the public meeting law, they are a public body. They must hold that hearing and make that decision in public with all the world to be able to see the actions they're taking. If they need to discuss something or have advice of their counsel, wearing the one hat of their private counsel. And I think it's problematic when the division, the same person in the division, serves as the prosecutorial counsel and serves as the private counsel. I would not ask for any private counsel related communications, because just as my communications with Mr. Castro are privileged, I believe privilege would attach to those. But where they are functioning in a prosecutorial capacity and they are bringing information before the commission, I think Mr. Castro cannot defend himself if he does not have everything, all the documentations. Now, the recommendation of the counsel as private counsel, a specific written report penned in hand by their private counsel in his capacity or her capacity as private counsel advising the commission on legal issues and law and procedure. I'm not asking for that private note or counsel advice to the commissioners, but all the documentation that they got for which the commission considered in making its decision is not advice of counsel. It is documentary evidence that Mr. Castro has to be able to see in order to defend himself. He has to know what they had before them and what they did not have before them, because we have written evidence that the officer who was ordered by the mayor, he should have been fired. He should have been summarily fired in Lawrence for disobedience of his superior officer and appointing authority's direct written order. He did not supposedly produce that. And we know that because the commission, the post commission through the enforcement council summarily sent the summary suspension letter and indicated there had been no investigation conducted. That is either a blatant lie by that enforcement council, or that is not a blatant lie, and enforcement council was never given the document that was ordered turned over by the mayor, which may have avoided this entire process because it would put a different light on the process. In addition,
wait a second. You said you have emails from the commission, from enforcement council to the person, the outside person, presumably. I know
Your Honor.
Department. I thought you just said that.
I have emails from people at Post. I did not, if I misspoke,
Okay.
my
People
apologies.
at Post. I'm sorry. People at Post. You said people at Post. So have you shared, you've submitted a fair amount of material in this proceeding already. Did I miss that, or is that included in that material?
I believe it is included, and we can go check through the foot or more of documents and reference the exact page where that was submitted, but it is certainly, I believe, referenced in my show cause response. But I will, Your Honor, again, review the show cause response and the documents. I believe we submitted that long ago. And there are also communications between, I believe they are Mr. Hartnett, but again, I will check the written documentation, and counsel for the city, ordering and directing counsel for the city to do something when counsel for the city has a duty, an ethical duty, to represent the interests of the city and the chief executive of the city, the mayor. Now, Post can ask, has an investigation been done? The problem is that was never done. That would have been the simplest, most rational thing to do, and communicate with the mayor's office and ask the mayor or his chief of staff or his senior advisor, did you guys ever do anything to conduct an evaluation of this car pursuit? And they would have found, yes, we ordered it submitted. Why don't you have it? Or they could have made a phone call to Mr. Castro or asked Mr. Castro to come in and say, you were involved in a car pursuit. We're doing a preliminary investigation. Was there any investigation of your actions conducted? And he would have said, yes, it was ordered to be submitted to you. Why don't you have it? None of that was ever done. It was a rush to judgment to strip Mr. Castro of his certification,
All
so
right.
he would be denied the position of chief of police.
All right,
That was
you
accomplished.
don't need to argue the merits of your motion yet. Right now I'm trying to get to the discovery issue. So number one, it would be helpful to me if you would direct me to any portion of the reply to the order to show cause. That you don't have to do it this second, Mr. Jacobs. I mean, just at some point.
No, I understand, Rob.
So I can um, be on the same page. It's just there's a lot of material there, as you suggest. I did look at it some time ago, but on this issue, excuse me, on this issue, I want to make sure that I'm on the same page that you are. So if you can direct me to that, that'd be very helpful.
We will send an email or notice through the usual filing referencing the page of the exhibits of either the show cause or the initial 7-inch binder we submitted to post. We will reference that, and I will try to attach to that as an exhibit the documents themselves so that Your Honor will be able to see it more readily, and Mr. Hartnett will be able to do the same. But we'll reference where in our production it was included, and we'll include it again.
All right. So I suppose what I'm going to need the division to do, Mr. Hartnett, did you even get a chance to read the motion that was filed yesterday?
Oh, I read it.
Yeah, okay.
Quickly. Yeah.
But it really goes to the issue that Mr. Jacobs is raising right now. So, and I do understand your argument because you articulated it, but I think you ought to put that in writing as well, so the record is clear. And all of this is going to flow over to the next most important part of our status conference today. And that relates to this pending motion to vacate the order of suspension. Clearly, I've had a chance to consider it. It presents issues that I think haven't heretofore been addressed by the commission or any hearing officers related to, it's a relatively new commission and it's a developing area. Many of these issues are new. But I can tell you that I haven't issued the order yet and I'm preparing it. But there are issues relating to that order that I need to discuss with both of you today. The fact of the matter is there's no question in my mind that at this point that the respondent is entitled to a hearing. And in fact, I think the division has recognized that. He's not asking for and probably has waived his hearing before a single commissioner. He's indicated in any event when he responded to inquiries from the commission that what he was seeking for is a hearing before the full commission, and I'm persuaded that he is. The question will ultimately be, what's the scope of that hearing? I know when we were last talking, Mr. Hart, you were suggested that in the few instances where there have been hearings related to the suspension order, that they've been abbreviated, to say the least. They haven't been in particularly in depth or a lot of material in terms of time or material that was sent to him. But I'm led to understand that in some prior matters, that the respondent himself or herself has been permitted to address the commission in person, that some supportive material has been received along the way. So there is some level of evidence, if you will, that's capable of being presented to the commission. Now, under the order that the chair issued back in April, I've thought about what I was really being instructed to do, and I'm also persuaded that I've been asked to really stand in the shoes of the commission, much like we do on the final adjudicatory hearing, take the evidence and make a recommendation to the commission regarding the relief that's being sought by Mr. Castro. So if I'm ordering a hearing, which I will be doing, it'll be before me in the first instance. I'll make what's sort of equivalent to an initial decision on the merits. but limited to the issue of a suspension, and present that to the commission, and they'll have the final word on it. I think there's authority in the statute for them to refer matters to a hearing officer for this purpose. But in any event, that's what I think that I'm being directed to do, and we'll do that. The big question will be, as we talked about briefly a month ago, is the scope of that hearing. And because the timing of this thing is unusual. Usually these matters are addressed early on, although there's no time limit for seeking revocation or vacating a suspension order. In most instances, it's happened shortly after it seems that it's happened shortly after the issue of the suspension. Here, a lot's happened since the commission ordered suspension. Preliminary inquiry's taken place. Order to show cause is issued. The respondent has replied in depth to the order to show cause. Discovery has been provided, although according to the respondent, not all that needs to be provided, but discovery has been provided to the respondent. And if we are going to have when we have a hearing on this, the question will be, what's the scope? We're not going to hold 2 final adjudicatory hearings. It doesn't really make any sense. And the way to focus on the suspension issues, to me, is for the respondent to be aware of what was presented to the commission when they voted to suspend. They didn't have all that we now have, that you prepared and I've seen, and the discovery that's been presented. Clearly, they didn't have all of that information, nor would they in the normal course of proceeding. But so that's why I would be inclined, unless I'm persuaded that it's something that I can't do, to provide the respondent with, in quotes, the evidence that was presented to the commission that led to the suspension. I think I was hearing you say, and that's why I stopped you and told you to hold on, because just to put this in context now, I think what I'm hearing you say is that at that stage of the proceedings, it's your position that you were providing legal advice to the commission, and whatever you provided in that instance would be protected by the attorney-client privilege. Is that your position?
Yes.
Okay, so how does the full commission, or somebody acting in that capacity, that is me, two questions. If that's not evidence that's part of the record on a motion to vacate, how does the division support support its opposition to the motion to vacate? What's before them? I know the defendant has, or excuse me, the respondent has probably lots of ideas what they'd like to present in support of the vacating it. But what's the other side of the coin? If they haven't seen what the evidence was originally before the commission, what should the commission or me and their on their behalf be considering?
Well, I think we are talking about 2 different things here. First, what was before the commissioners at the initial session, that is a question of that would be more proper for a single commissioner hearing. That's the issue of the issuance of the suspension. If we're talking about revocation of the suspension at this stage, now we're talking about, is it appropriate to lift the suspension that has already been issued. There's a presumption that it was issued properly, and now the question is then, is it appropriate to lift it now? Which broadens things, and that allows a respondent to argue new things have come to light. Like, for example, people in the past have said, I was charged with a felony, now I'm not. So that's an important, significant change. Here, he could make his argument, and, but there's also new allegations of, and then the problem is then really the argument for suspension is the argument that is the whole issue. I mean, it's everything. It's the whole set of evidence. That is the reason, so it would be the whole body of evidence. And that's where we would be getting very close to just having a whole nother mini trial, which is, we really shouldn't be doing. I mean, if you're seeking to revoke the suspension, that is a special request for which there is no statutory framework for how that even gets done, and even any real standard for why that needs to be done. It's given the commissioner's full discretion on when to do that. It's a very discretionary option to do that, and so, but the commission has, in order to respect due process, allowed certain individuals to come and present an argument for what has changed, and they can testify about themselves. They can they can present if there's certain, evidence out there, like, evidence of a change in their criminal case or something like that. They were able to present that, and then the commission could vote on that. And that's what it's been done in the past. If it's going to be, I'm not. So it's a little difficult to answer that question.
Well, but two things I agree with you, probably no more than two. I agree that there is no, it's not defined what that process will look like. It makes a difference about when it's made, in terms of when the request is made, in terms of defining the scope of that hearing or that meeting. The only thing that's different about not the only thing, one of the things that's different about a single commissioner review is it happens almost immediately after the issuance of the suspension. This could happen at any time, and it is happening at a much later date when much more has happened. So it brings me back to, let's say, about what you think the the division is entitled to do at the presentation, whether it's before the full commission or me on their behalf, what you think you're entitled to present in opposition to this motion to revoke. And if you, like me, feel that this should not be essentially the same as the trial on the merits of the order to show cause, then how does one limit the scope of this, given where we stand in the overall process? Because if it's your position that, well, we know more than we knew at the time the suspension took place, and if they're raising certain objections, like, just to use an example of what's talked about today, that there was an investigation conducted when that wasn't made clear to the commission in the first place, and may have even theoretically been unknown to the enforcement council at the time that those proceedings were taking place. Theoretically, I'm suggesting, should you be able to address all of that? Or are you limited to what you presented initially?
Oh, no, I would be able to respond fully to I have to understand that he needs to present the argument first, really, right? And then I can respond to it and I'll respond to it, and including, any evidence to the contrary. I'm happy, and that's including evidence that's been turned over, or evidence that I know he has because he's put them in documents. That's no problem. There's a whole there's a whole host of evidence that suggests that vacating the suspension right now would be improper, improper and not warranted at this point. I mean, most of it is the bulk of what's in the order to show cause, and the order to show cause itself is a good reason not to lift a suspension. We're about to have a hearing on, right? So, you know, if we have a hearing, and at the end of that hearing, you know, it seems appropriate to lift the suspension at that point, that might be something to do. But
well, except that there's different standard proof, isn't there?
Yeah. Oh, yeah. Oh, yeah. I mean,
your burden is greater on the merits than it is at this stage of the proceedings relating to this issue.
correct.
Although there's a presumption that it stays in place unless they make the showing. So it's actually becomes their burden to overcome the suspension, doesn't it?
Yeah. I mean, and if after we have an evidentiary hearing that you didn't feel that there was even that level, I believe a very unlikely circumstance, then you could lift it. But at that point, while we wait to have it go reviewed, or you could put, it's a little hard to talk in abstract here because I don't know exactly what he's, it's been a little bit all over the map in terms of what the argument is going to be in terms of, first it was unclear what we were even arguing for, and then, the grounds for it. And it's, if we're talking about the actual issuance.
But wait, so it's inevitable that Mr. Jacobs is going to say, well, I've got lots of issues on the merits of this thing, but I don't know what led to the suspension here. I don't know what was presented to the commission. So how do I present to the commission today, or again, me in the position of the commission, a response to that, to be able to say, because there's no question. I mean, I have a sense, thanks to my review, about what was presented to the commission initially on the suspension issue. And you can acknowledge without interfering with any rights, anything to do with confidentiality at this point or attorney-client privilege, that the order to show cause is obviously broader in its allegations, and the issues surrounding the order to show cause are greater based on what the respondent has raised in response to it than what was it presented to the commission initially. It's a matter of time. I mean, everything else.
Sure.
But so doesn't, in a way, that circumstance, even just the way you're describing the scenario, invite because the respondent isn't on notice of exactly what led to his suspension initially. Doesn't it invite the kind of broader inquiry that goes to the ultimate issues in this case?
Well, he does receive notice of what the grounds are for the suspension. He receives that in the suspension order, and he receives a notice saying, and he receives a notice of what the scope of the preliminary inquiry is going to be, which he has.
He gets statutory notice under what provision he's being suspended, right?
No. The notice is descriptive of what it's not highly detailed, but he knew at the time that a preliminary inquiry was open what the initial grounds for that. But of course, we keep open the fact that he knew things could develop, and in fact, one of the allegations in the order to show cause is that he violated the terms of suspension, which that didn't happen yet, so we couldn't notify him of that. And then.
But even let's put this in proper perspective. What the order of suspension tells him is that the commission received sufficient evidence that the respondent engaged in a motor vehicle pursuit in violation of the policies of the department, that he was untruthful in a subsequent written report regarding that pursuit, and that he or his appointing authority failed to independently investigate whether there was a policy violation or report the same to the commission. And then there's also credible reports to the commission have called into question the respondent's hiring and certification practices concerning certain candidates for employment as law enforcement officers for the department. So that's what you mean when he's on notice?
Well, yeah, I mean, and he that gives him enough notice to know exactly. I mean, he knows when he saw that, he knew exactly what we were referring to. It's in a specific incident that he was very aware of at the time. He would have known all about it. I mean, you know, we've turned over. He has memos where he's writing about it. Like he clearly knew about it. And then I'll just say as a side note, the hiring stuff is not in the order to show cause, so it's not really relevant anymore. And it's not something we're trying to that we brought forward there.
Well, isn't that a good example, though? If that's something that was presented to the commission and led to his suspension, and it's no longer part of the case against Mr. Castro,
Well, it did not lead.
isn't that a basis for going and saying, hey, commission, you know, what you decide this case is it's more limited or different now than it was at the time suspension was sought?
I think if you, I mean, I'm cautious here to overly describe privileged documents, but there are, I think if in the documents that were turned over, it is made clear that the suspension is not based on those set of charges. The suspension is based on purely the
Okay,
the
I get
pursuit.
where you're going. And
pursuit.
it's been a while since I looked at what I
Yeah.
reviewed in camera,
Yeah.
but I will
Yeah.
certainly focus on that.
And those also existed, and they're noted in the order because they also exist, but they're noted separately. They're noted under a different standard, even in the order. The order talks about the first set of things being at a certain level, evidentiary standard, and then that they're just saying that also happened. And I acknowledge that that's confusing, but
Well, it suggests that they considered it. If they put it in their order of suspension, they certainly.
Sure, but they couldn't have considered it for purposes of the suspension because they make clear that that there was also credible evidence of that, which doesn't mean that credible evidence would not be sufficient to suspend him. It would have to have been the preponderance evidence that they had before them, which they referred to earlier in the order. So that we know what they based the order on, and that just wasn't what was requested. So
actually, the preponderance of evidence standard is the sentence that says they made a finding by preponderance of the evidence follows directly after their sentence about credible reports of relating to hiring.
I mean, I don't have the order in front of me, but
well, you can trust me on this one.
Yeah.
I just have it in front of me. So my point is that I think my question probably still applies. They had it in mind. They said everything that they've just related to both the pursuit and the report and the hiring and certification practices seem to be matters that they considered whether they satisfied the burden of preponderance of the evidence to support suspension. So, but I understand that. I mean, that doesn't change the overall question I have here, which is whether what we're doing as a result of all this is whether we're just simply going to be duplicating what we would do on the ultimate question here. And does that mean that, well, maybe there's a limitation on the presentation, but how can that be sort of, and that has to be done because of a reason. You know, the scope has to be measured because of a matter of legal entitlement and relevance, and the fact that there are no precise guidelines for what kind of evidence can be provided at a request to before the full commission to suspend or revoke the suspension. There are no guidelines for that. And because they have done it in somewhat of and that there hasn't been a lot of this, I don't think, before the commission yet anyway, a full commission as opposed to a single commissioner. So it's not, the guidance doesn't come from history except and precedent, except to note that I'm aware of at least one case where as I said, the respondent testified and other support for his or her position was presented to the commission. It may have been not a lengthy proceeding, I don't know, but I don't see any reason why this respondent shouldn't be entitled to at a minimum the same kind of opportunity that others have had, as distinguished from what happens in a single commissioner proceeding. I mean, do you?
No, we have no problem with him, testifying or making his argument before the commission, as long as we get a chance to respond. And it's up to the commission. It just depends on how long we want that to be. But in previous times it was short, and maybe it needs to be a little longer, but it shouldn't. But no, we understand that he has a right to at least ask for this, and he can have a hearing on it. But that's a hearing, it's more akin to a motion hearing. Although I understand that there are some, he would be presenting those things. But it's not a full blown evidentiary hearing, and it's certainly not a full trial.
Yeah, here's an example, just in the context of this case itself. If one of the allegations is that there was, he got in the way of the fact that a full investigation wasn't done, and all of a sudden they come forward with what they claim to be a full, he claims to be an investigation that you folks say didn't take place. I mean, wouldn't that be relevant?
Sure. Yeah, I mean, yeah.
I'm biting
my tongue not to get into the meat of that, but I'm happy to. But that specific allegation is, it's not accurate based on, and I was accused personally of lying in this hearing about that. But I'm happy to address it in another hearing.
Just so that the record is corrected, I did not say, Mr. Hartnett, that you had lied. I said that either the summary suspension where that allegation is made is a lie, or the commission was never given documents that were ordered to be given by the mayor after the investigation was conducted of the car pursuit. I put it as an either or because they both can't be true. And we have the emails suggesting that Lieutenant Rossi, and we have the emails to Lieutenant Rossi, that he was ordered.
We went down this road, and you're going to give that, you're going to point that out.
Yes, Your Honor.
So that I can deal with that. But I'm not deciding this issue right now. I just want to make that clear. I'm really just trying to define, and it's a difficult process, quite frankly.
I appreciate that, Your Honor. And I realize you're not.
I'm also, the issue of privilege still, I find to be a quandary, because I do think that by nature of the way this has all been set up, that I think this is not unusual necessarily in other administrative contexts where counsel that pursue these investigations on behalf of the commission also provide advice and counsel to the commission itself. So they do wear two hats. And somewhere along the line, I'm like right now, might have to decide whether anything that they presented to the commission in the first instance is protected by the attorney-client privilege, when in fact they're not acting as counsel to the commission in the context of the hearing we're doing.
I think we might also need to distinguish between what they provide as their handwritten advice or counsel to the commission versus the documentation that they submit into evidence to the commission. I think there's a distinction between the two, but I think a more important issue is one of, is the commission allowed in executive session as a public body to make a suspension order where there has been no public vote taken on that decision. This is the first that we're finding out from the results of the discovery that there was apparently no public hearing and no public vote and decision, no minutes, acknowledging everything is being hidden under the guise of executive session. I understand executive session, but statutorily it is limited what a public body has the right to enter into executive session for. They, I believe, can enter into executive session to discuss something with their private counsel. But as far as taking in evidence and making a decision and a vote, I believe that has to be held in public.
Well, that's
And
why
I'm
I've
told
asked,
it was not.
well, that's why I've asked Mr. Hartnett to respond to that issue in writing. So I can understand their position.
Thank you, Your Honor.
And in fact, when could you do that, Mr. Hartnett? How much time you need for that limited issue?
So I'm actually supposed to leave town later this week, so if I could have to the end of next week to
Yes,
respond.
you can. That'll be, so, Lizzie, you're the person with the calendar.
Yeah, I
Just
have it up.
to
So
put
the
it
end of
in-
next week would be like Friday, August 1st. Does that work for you, Attorney Hartnett?
It does.
Okay, so how about submit it by 3:00 p.m. on Friday, August 1st?
Sure.
Now, the next question is the timing of, okay, actually, I'm going to make your burden a little bit worse, Mr. Hartnett, greater, not worse. I do want to hear in writing your position on whether what was submitted to the commission in support of the request for suspension is attorney-client protected. So I'd like you to add that to your memo, and if that's something that can be accomplished in this same period of time, that's fine. If you think, can you include that then?
Yeah. Yes, I mean, these are two separate things, right? I mean, one
Yes.
is I'm responding to the motion for the discovery motion that was filed yesterday. But then, I mean, I'm happy to submit something on our position on to follow up on what was already submitted to you in terms of our position on those things. Yeah.
Well, you submitted for in-camera review. Are
Right.
you talking about your opposition to their motion for a hearing, or what you submitted in camera to me?
What I submitted to you in camera is everything.
No, yeah, I get that. And the question
So-
is now, do I share that? Do I order it shared with the respondent for lots of reasons? One, for notice, and I understand your arguments that they had notice in another sense from the order itself. But also in terms of defining limitations on the scope of this hearing. And you know, and implicit in every issue of due process is one of notice, and that's why I'm concerned about it. It may be your position. It sounds like it's going to be your position that no, what we were doing what we submitted at that time is protected by attorney-client privilege. That's fine. I just want to make sure I have that in writing and your reasons for that. All right.
Okay.
As a point of clarification, Your Honor, are you also asking the division to address the issue of how the vote and decision was taken?
Well, that's the executive session argument that you're making and public hearing.
That is
Right.
correct. Not
Right.
just the show, not just my motion for the privilege log, but also the issue of the vote itself. You asked it, Mr.
Well,
Hartnett.
I was focused on your argument that this should have been an open hearing. So I get that. So, and that's what I'm asking for their position on. Yes.
All right, thank you. Because the motion also included documentary evidence separate from the hearing being open itself, because they have listed things as privileged, confidential, and work product. And I think if they're going to do that, they should at least identify what it is by date and parties, and just say email communication or whatever, and do a privilege log so we know and can then discuss whether they are indeed privileged communications.
Well,
We need to know.
but you've already stated that you're not talking about sort of administrative communications or commission or communications from other parts of the commission that they don't have control over or even possess, or communications that would naturally not be available to a respondent, for instance, between the hearing officer and with the hearing officer. You've already acknowledged that you think that needs to be subject of a privilege law.
Those specific ones, no, but any communications that the division had, even by division counsel, with anybody in the city of Lawrence, that is not attorney-client privilege. Those
Well,
communications.
I heard Mr. Hartnett to say that, and I may have misunderstood you, Mr. Hartnett, but that you weren't claiming privilege as to that,
I'm not claiming privilege, I'm claiming those are confidential.
or confidentiality.
Those are confidentiality under communications with third parties are obviously not attorney-client privilege. That wouldn't be
No,
here.
no, I'm sorry. I misspoke. I know that you're talking about
Yeah,
confidentiality.
it would be confidential. No, we raised and we asserted the confidentiality clause in response to any request that would include, the communications that go to, how we investigate things and who we spoke to, and but not necessarily the documents themselves, which we've produced. So
So if it turns out that there's some communication out there from the division to third parties that you don't have to give us X, Y, and Z, and that happens during your investigative process, that's something that's confidential.
well, if he's suggesting that it came from someone outside of standards, in which case that wouldn't be, but it certainly didn't come from me. But if there was, no, if we were communicating with a witness during the preliminary inquiry, that could be confidential for sure. But if somebody else in some other division was by chance talking to someone in Lawrence, well, that might not be protected at all. And happy to turn it over if it exists.
That's why I'm looking to be focused on exactly what Mr. Jacobs was talking about and what he's going to do for us is provide reference to where that.
The problem I have, Your Honor, is I have certain emails which we will definitely produce. I believe they've already been produced, but we do not necessarily have other emails that we don't know about which exist. And if Mr. Hartnett believes something is confidential, I believe that's subject to a privilege log. I'm not asking at this point in time it be released. I'm asking it be identified in a privilege log. That's the standard in a production of documents. If you withhold documents that are relevant, then you produce a privilege log. I'm not asking for simple scheduling issues between secretaries and assistants to be identified or anything with respect to Your Honor.
Right. I got it. Well, I think that your reference to what's been provided already will help me define the entitlement and scope and requirement of a privilege log. So I look forward to getting that from you, Mr. Jacobs.
Understood, Your Honor.
All right. All right. So what I want to do is look at the 7 pages of notes I've written in advance of this hearing. So hold on a second. Let me ask you this, Mr. Jacobs, just straightforward. Do you envision that you're entitled to the kind of full adjudicatory hearing that your client is entitled to on the merits of the claims of the order to show cause to address the question of suspension?
I think he has the right to argue that the suspension based on only on the 4 corners of the suspension letter did not justify a summary suspension. Certainly, we know parts of that have been removed because the division has already accepted he doesn't hire and fire and he doesn't certify. It's absurd to have suspended him on the basis that he's improperly certifies when the post commission certifies, not anyone in a local municipality. And then the issue of there was no investigation was another significant issue raised, justifying summary suspension. Remember, a summary suspension done, no communication with the respondent before the suspension, a destruction of his career, and he was in the running for the chief of police, which was destroyed. Very serious consequences, and I believe he has the right to show this was improperly done, not only most likely not done in public like it is statutorily required, but not even evidentiary sufficient to justify the suspension. And what we need to know is whether the individuals that are prosecuting Mr. Castro are in any way related to limiting the information that the city ordered turned over so that they can go ahead and do this suspension. We don't know that. We don't have the communications. We have some communications telling basically Lieutenant Rossi he doesn't need to do what the mayor ordered him to do. We don't know if there are others out there. We don't know if there's other misconduct that then led to a limitation of evidence and led the commission to make an incorrect decision because they were blocked from having true evidence. And certainly Mr. Castro wasn't allowed to speak.
Mr. Jacobs, I'm going to interrupt you for a moment. Number one, this is the third time I'm hearing this. So, and it takes me a little while, but it doesn't take me 3 times to understand what you're saying. And secondly, I don't want to argue the merits of the suspension at this point. I'm just simply trying to get a better handle on what you envision the scope of the hearing to be. And I think you've expressed that. I understand that you think that you agree, as I would, that it's circumscribed by the grounds that are raised in support of the suspension in the first instance. So the second thing I want to do, I'll decide once I get a submission from the division about A, whether a privilege log is appropriate, B, whether you're entitled to what was any portion of what might have been presented to the commission at the time the suspension was ordered, and any of the further discovery issues that you've raised. But I want to do that. We've waited long enough on this issue. By the way, maybe in part the fault lies with me. On the other hand, it did take 10 months for somewhere in that neighborhood for the respondent to reply to the questions from our branch of the commission as to what you wanted in terms of a hearing, whether you were seeking a single commissioner hearing or a full-blown hearing before the commission. So the sort of the timeliness of this is impacted by all of that. And but now that we're doing it and we're getting geared up for this thing, I plan to do it in short order. And so one of the things I want to accomplish today is to set a date for the hearing on your motion related to suspension, and also to set a schedule for the final hearing. And if those two become, too close in time and too duplicative of each other, then we'll have to determine whether both are appropriate. But in the first instance, let's get a hearing date on the motion related to revoking the suspension. And generally, what are the council's availability in late August?
I will be out of state the week of the 17th to the 24th.
Okay.
Judge Fishman, it looks like Mr. Castro raised his hand.
Oh, I missed that.
Your Honor, August 20 is, I have a commitment.
Okay, thank you.
Thank you, sir.
But it sounds like that. You said, Mr. Hartnett, the week of the 14th and the week of what? I'm sorry.
Sorry, it would be, so the week of the 18th, that Monday is the 18th, so
Oh, okay.
18th to the 22nd. I said 17th, that's what I leave on a Sunday, so it's on my calendar that way.
Yeah, I hear you. And then the following week, you're also unavailable, the week of the 25th?
No, I'm available that week.
Oh, okay.
I can be available the 27th, Your Honor.
Lizzie, does that work on our overall calendar?
Yes, that's fine. And would this be in person or remote?
No, I want this in person.
Okay.
And let's set it up for the August 27th. There's no reason that can't be done at the post commission, is there?
No, so that can be held at the Post Commission office at 84 State Street. And how does 10 o'clock a.m. work for everyone?
That's fine.
Yeah, that's fine.
Does that work for you?
Sure. Yes.
I know your commute there takes quite a while, so it's being facetious. Okay.
And just to confirm, this is the hearing on the respondent's motion.
Yes, I forget the exact title of it, but I think it said to vacate the order suspension, but I don't
Thank you.
have the motion right before me. Is that right?
Yeah, I believe so, Your Honor.
Yeah. The order I issue will confirm the date, obviously. It'll confirm what's going to be additional, what I'm ordering provided or not ordering provided to respond in advance of the hearing. And the best as I can, define the scope of the hearing, really to make sure what we're doing isn't the kind of full-blown hearing that you're entitled to on the merits of the allegations against Mr. Castro. Are there any other issues that you think we need to resolve today?
I don't believe so, Your Honor.
Mr. Hartnett, anything else?
No, Your Honor.
All right. Just one more look at my list.
Judge Fishman, just to confirm, did you also want to schedule the date for the final
Oh,
hearing as well?
yes. Thank you. See, that's why I'm glad you're here for a lot of reasons, Lizzie, but that was what I just said. So I think it's important to do that, given the time that's gone by. Do you have a sense of how long the final hearing will be?
Couple days. I mean, it would part of it depends on how much. I mean, it's dependent on the other side as well, so I don't really know, but I would think at least a couple days.
No, and I know, I'm sure that there's guys, but I'm going to be incorporating in there as a motion date before then, sort of address motions in limine that probably will impact the scope of that hearing. And I think everybody has a sense of the scope based on Mr. Jacobs' arguments along the way and the submission in response to the order to show cause. And I suspect that there'll be some challenges to what the division believes would be relevant and admissible on those issues. So let's get a final date, and then we'll have a date fairly shortly before that for motions in limine. Okay. And I think I agree that it sounds like it's a couple of days. So we just set this for the 27th. About early October
I don't have several days together, Your Honor, until the 20th.
of October?
Correct. I have several trials and hearings already scheduled in courts such that it would be a problem. Some of
Okay.
them involve multiple firms.
Okay. What about the week of the 20th of October? Is
Week
that,
of the 20th is open, Your Honor.
Mr. Hartnett, does that work for you?
It does. If it's possible, I would prefer it later in the week, but that's fine. The 20th.
No, this is the time to do it. Might as
Yeah.
well accommodate as best as we can. What about the 22nd and 23rd?
That would be fine. And then we can pencil on the 24th and keep it open. I'm no problem with that.
Meaning the event goes longer?
Yes.
Right. Lizzie, does that work?
Yes, that works. And would you like to start at 10 o'clock a.m. again?
Yeah, it's funny. I know we've been doing these at 10.
Mhm.
In my other world, I was usually an earlier starter because you get more time during the day. But
Sure, whatever you prefer.
nobody ever says that to me. That's very touching. I really appreciate that. How about 9:30, just so we really get going in the morning for the.
Sure. And location to be determined right now. We'll send a scheduling order with all of the dates that we just proposed. So that'll have more information.
All right. So having said that, I'd like to have motions in limine. Um, if you can pick a day earlier in the month, that would be helpful that you are available, the counsel are available.
The 10th of October, Your Honor? Do you want that in person?
We can actually do that probably by Zoom. Are you available earlier that week at all?
I can do the 7th, Your Honor.
Does that work for you, Mr. Hartnett?
Yes.
Okay. So what I need is the parties to file. Um,
Judge Fishman, Mr. Castro raised his hand again.
yes, Mr. Castro, you have a problem with this 7th?
And the 7th of what month are you on?
October.
I'm open, so.
Okay. So I just want an opportunity for a date that you exchange your motions and then you file have an opportunity to prepare oppositions. Just give me a sense of how much time you think you need before the 7th. No, the 7th is a hearing date, so I need a filing date. I'm fine if the final motions and oppositions are filed the week before. Let's say the 30th works for me. But just give me a sense of how much time you think you'd need to prepare oppositions to each other's motions.
I think if they're submitted by the 23rd of September, that should be adequate.
Okay. You both okay with that?
Yes.
All right. So why don't you file the motions by the 23rd, file your oppositions by the 30th. Hearing then on the 7th, and the final hearing from the October 22nd and the days following, depending upon how much time we need.
Now, when you say the motion's eliminate to file on the 23rd of September, do you mean to serve them to the other side or also file them with the commission?
You might as well file them at the same time, but I'm giving you a week to file your oppositions after that.
Understood, Your Honor. Thank you.
Okay.
And sorry, Judge
Yes.
Fishman, go ahead. I was just going to ask, what time would you like the final hearing before the motions? Is 9:30 a.m. good
Yeah,
for everyone?
that's particularly if we're doing it by Zoom. I think that's fine.
I have October 24 here. Which one is that one? This is the hearing weekend?
So the final hearing starts on October 22nd, and we have the 24th kind of on hold in case proceedings take longer.
All right.
And this,
Give us a little wiggle room.
And if the parties could please file their motions with the commission by close of business, so 5:00 p.m., that would be helpful.
All right. If any other issues come up beforehand, you can file what you need to file and we'll address them.
Thank you, Your Honor.
All right. All right. Thank you all. I guess that does it. Thank you.